Hello, good morning everyone. This is Deep Kumar Mohanty and I am currently practicing as an advocate in Odisha High Court, Bhubaneswar Trial Court, various commissions as well as the National Company Law Tribunal. And today I will be sharing you with some efficient tips and strategy relating to moot courts. So first of all, let's start with the basic thing that what we mean by a moot court. As all of you know, moot court is a virtual courtroom where, basing on a fictional proposition or case, two teams they argue on either sides before real advocates or magistrates or judges. So, in a moot court, as we have two mooters and one researcher, so in order to perform efficiently in a moot court, it is essential that the mooters as well as the researcher, every member of the moot court should research about the moot court problem efficiently. All three members should research. It's not only the job of the researcher to research, which is a misconception. Next, after reading a moot court problem, first we should try to analyze that the moot court problem is based on which law, and if it is based on various laws or one law, then what are the relevant provisions, sections or articles under which the moot court problem is based. After researching those things, then we have to link the provision with the facts mentioned in the moot court proposition and then substantiate our arguments with leading Supreme Court judgments in order to make the arguments advanced portion of the memorial an effective one. If I have to share some effective tips for drafting a good memorial, then it should be, first of all, strictly adhering to the rules which are mentioned in the moot court competition. You should adhere by the rules, the editing format, like whether it is a blue book edition for citation style footnote, or whether the footnote and the editing should be as per the Oscola. So we should strictly adhere to the editing style and what should be the font size. Next, it is important that the legal language which we use in our arguments advanced portion, the statement of jurisdiction and other things of the memorial, the legal vocabulary language matters a lot. Also, it is important that after framing the issues, if we make some sub issues or subheadings which you can say in the arguments advanced portion, then it is eye catching and it is also will give you more marks because you will be able to divide your arguments into some various subheadings. So these are also an effective strategy of drafting a good memorial. If we come to the oral argument presentation, then what matters is that while submitting our arguments, we should neither be too much aggressive nor should our voice be too much low that it is not audible. It should be polite, decent and loud enough but not aggressive. That is important. Next, while submitting our arguments, it is essential that when judges who ask questions or the grilling of judges which we face in moot court, it is essential that we should listen to their question properly and try to answer them effectively instead of following or continuing our own arguments. So if any judge asks you any question while you are submitting an argument in the moot court, try to answer that question first and satisfy the judge. Now what happens if a first speaker is speaking in a moot court but the judge asks the question which relating to a issue which you all had initially planned that issue would be answered by your second speaker. So in such an event, even if you know that your second speaker will address this issue, it is beneficial that you answer it then and there itself and state that, my lord, this is the answer and further this will be elaborated by my second counsel. If directly you will say that, my lord, no, I am not able to know this answer because this issue will be dealt with by the second speaker, then it gives a wrong impression on the judge. The judge will have a wrong impression on you that perhaps you are unable to answer the question. So it's always good to answer the question a little bit. If you do not know the answer, then try to convince the judge that I am unable to answer this, this will be addressed in detail by the second speaker. But it is always beneficial that you answer it first. Next, another strategy which I would like to share is never reveal every argument in your memorial, because in national or state level moot court competitions what happens is that there is memorial exchange before the moot court competition. So your memorial gets exchanged with the opponent team's memorial and the opponent team has your memorial. So if you reveal all your arguments in the memorial itself, then the opponent knows your arguments and they will be able to counter it more effectively. Whereas if you mention your arguments in the memorial briefly, but you save some of points of the arguments in your oral argument presentation, then it will be beneficial, because then they have to, your opponent team will have to counter it then and there itself. Next, what is important during oral argument presentation is you have to strictly adhere to the courtroom etiquettes, like addressing my lordship. If there's a male judge, if there are female judges, then you have to address them as your ladyship. Then it is also important that while arguing, you should not be reading from the memorial or from any arguments which you have made. It is always essential to maintain eye contact with the judges. So these are some effective tips for participating and effectively performing in a moot court competition. Thank you all.